also no medasi.
Okay. Asemje kai nyina.
So.
Okay. I don't know. Rex, is it okay, sir? Obviously, I enable me, so now I can share my screen now. Okay. And it's okay.
For just some few seconds.
Okay. Okay. So whilst we wait for, but you'll be at me car.
Loud and clear.
Great.
Please, you've been assigned as the co-host of the meeting to Ubetimi share.
Right.
Those slides, okay. Yeah.
Just a minute. Just a minute.
All right. Okay.
Unfortunately, I'm having difficulties sharing my screen. With from I will do the presentation minus me screen. All said and done, time is fast spent. So let's quickly have a quick prayer and we'll proceed. Father, in the name of Jesus, we are thankful to you for this day, the opportunity given us, to me specifically, to share the knowledge I have with my peers. It is my prayer that this evening will be something that would impact many of us here, that would learn and take something away from it, that our lives would be improved given the knowledge we are about to ascertain ourselves. In the mighty name of Jesus, we pray. Amen. Today, we are privileged to talk about cohabitation and divorce. And very often, we hear things about, let me put it this way, back in school, those of us who were privileged to be in uni, parts of uni where we had to stay on campus and all those things. We used to see things where, some of our colleagues, some of our mates would have, let's say, their girls living with them in the halls. And we knew that this person, they were dating or they are together. They do everything together. The only thing we do not know, the only thing that is not formal, the fact that they are not married. In the same way, when we look at the bigger picture, there are three kinds of marriages acceptable here in Ghana. We have the customary marriage, we have the Mohammedan marriage or the Islamic marriage, and we have the marriage by ordinance. Now, cohabitation is a form of informal marriage that is characteristic of customary marriage. So one would say what is customary marriage? I'm sorry, what is cohabitation? Now, from a decision of a court stated in Quave versus Quavy says that, and I quote, it says that when once it has been proved, therefore, by proper evidence that the parties have agreed and have lived together in the sight of the world as man and wife, that of itself is sufficient. The court should hold that the parties are married according to native custom. Near Makasisi, near Mrane Pache, say, even though say you war formal marriage where Obama and in the Busia able to a normal ako Obani and the Busia fee akase na yabehu obebi waha na yepese yebe no wade near Ninkufie. That is the formal way of marriage. However, no, sa cohabitation say Obama ni oba muti nemum one worry abusia emfa nsa nko and abusia nso enje oba ni tiri nso nsa anase sika anase bibiara ewo amamre mu no anase won amamre mu ehwe se won aware enti no yaba yakan culture no mo. They are one of the things I better say aware akoso no say obema ede ensa enebia anase schnapps eni sika ebeko oba fie na watch say we are showing our intention to marry. Cohabitation there the biara sani ho one me no neti ye kwa adwuma ye ba ye kɔ ha ye tibom ye bibia say aware na mum ye worry. Now obi be bisa say cohabitation koswa. What are some of the things that can be inferred from the cohabitation?
But I ton kapa.
Great. So say you have to say obema ni oba eti. Now one worry. Now somehow obema no eye anase oba no eye ejapade. Ye bekomu no ebia na oba no ato car anase wato asase. Na me fasa before they actually got the opportunity to get married, Obano, if you know, na Obano say, Obano ejapadena wejano, who gets the benefit or who has the right to it? Ordinarily, Rebecca say one who na our area. Rebecca say Obani ni hodia enya bema no ene hwe na japade so Sarah so ne ka say obema ni ho oba no ene hwe na japade so. But this is the case one mienu no one worry abusuafo no enhu emfa enka say yaje etiri so nsa yaje sika yaje say you recognize say mo worry. However no senior one ko eba ni didi boom na ye three boom na ye ko sorry and everything they do it together and the community recognizes them as a couple. The question is, what happens when death comes in? Is the person able to succeed the other partner? In Tianumi, you better case be a court no decide na case na obema any oba and a wo and oba no efimu na oba no fimu no emramu ye will be a friend no letters of administration is answer na omo person mo koje sa early no se na be ya oba no japade no obo betumi ache na sa early no se obe apply you must view of capacity and now say abusiano e will say abusiano recognize you will say you're the person to come for it into no one court no and America say judge ni bisa say na I mean sorry Bearman no enter be a friend caveat in your objection actually say onu na obia or apply for eleno and now America ko mu no e bisa say oba we any obema we no ma worry ana on say there be and you bisa maame ne say obema no why bibia e chere say opeso oni oba no a chere say oni oba ne hye and now say his what declare the intention to marry the woman and a few woman anwa or say yes or the ensa abefie waba bebo kokoko na mum the e was obey no e ma the broni be say the essential validity that would make the marriage, that would finalize the marriage, no the omeye. But not almost say a boom. And the America say Sadia say just because omeye sa we no na me recognize say mobano excellent chain na se bibi esia ono na moko ne wodia ye fane say and as we infer the existence of an informal customary marriage amongst the two. You know, a manushe no, even those on worrying, letters of administration to administer the estate of Oban. Now the question is, the biarano e was say, Ode ensa eko anase okoboko and the chest you are cohabitating and sometimes you may not have taken drinks or any customary things to show or to ascertain responsibility. There are some actions that you will do. For instance, Obana now Obana fell through or she becomes pregnant. I hope I got the tree right. And so there are some things like the lady gets pregnant and then the gentleman goes on to say, and I say, man, the bush for eba obani fie ebeka say, in same way, no, me dear. Nemu me wari obani into no eba naming ceremonies and all those things now. Obano, I'm sorry, the Bemano taking responsibility. Nemu Obano ebusia NJ eson sabia na. They will recognize that indeed there's an existence of marriage. But they cannot say. Hello? Good. You know, it's all about cohabitation. However, because we are having this conversation in the context of Christianity as young adults of this church, Obibi bisa say, it shall say, ye baby bisa na. The law would give rise to some of these things. We would be allowed to come and make arguments. Now, arguments now, it is at the discretion of the court. They will listen to the other side. Even though, say, we are principles stated in cases, and this straight jacket say, uni obi shehwa, na say, bibi sa bemwa, Japadian bibi sa bemwa, and this straight jacket say, it will be of benefits to you. Nankampese, if you are a young adult of the Presbyterian Church of Ghana, you need to ask yourself, say, a child say, uni ubi you have not been recognized by the family, say, formally say, I will leave this part of Sa topic way for us to deliberate on personally. And I believe when the floor is open for us to have or to entertain questions, I believe others will have questions to that effect. Now, we will move on to, when it comes to cohabitation, the subject is very, very simple. And we'll move quickly onto the second aspect of today's discussion that talks about divorce. Now, divorce, say, main canon say rhetorically, say divorce is to say if I kente in the sense say obiara waria. One of the common things that you'd find kente. Obiara she kente it's a very common. In the same way, divorce has become common. Divorce has become very synonymous to our very existence of marriage life. So the question now would be, say, what is divorce? Can anyone hazard a guess? Anyone? Hello?
Hi. We are here.
Yes. Can anyone give us an idea of what divorce is, a definition of divorce? We are having a discussion.
Oh, I want to ask, has the discussion been on for a while? Because I just joined on.
I think we just started. It's in two parts. So we're looking at cohabitation and divorce. We've just, talked about cohabitation briefly. We're about to move on to divorce. And so I think you're very much lucky.
Okay, so you just wanted a definition for the divorce, right?
Yes.
In my understanding, not the legally accepted way, I think it's when two people who are legally married decide to come together and say that we are going separate ways and then we want to cancel the contract that we signed as a couple.
Nice. There's not much to take from it or subtract from it, except to say that when we talk about divorce, from the legal point of view, it is the voluntary decision by a spouse or the spouses to discontinue with their legally accepted marriage. Now, I don't know if the one controlling the slide, can we move to slide 5? So let's go to the next slide, please. Good. So the question now is, now that we know what divorce is and the fact that it should be voluntary, let's look at the situation where they say that marriage is between the families. In Ghana, we say that the marriage is not between only the couple, but it also takes into consideration both extended families. Now, if you look at our customary marriage, or customary marriage as a whole. One of the things that happens is that obi say, "Mede meba aba, mede nsa na mode bae no, aware no yenya aware bio, nti mede nsa na ba, yebefa yeba akọ." I believe this is something most of us can relate to. However, when it comes to divorce, as it exists within the laws of Ghana, any person outside the parties, and here the parties are the man and the woman, nobody outside these two can bring an action for divorce. They cannot apply to the court and ask the courts that we want to be divorced. It is either parties would mutually want to, and this point, as the conversation goes on, we will touch on it, or one person would say that, "Aware no mean to me worry you." Say, "Ain't na mean to me worry." Ain't no, but aware no, eba every. Now, you share slide near what screen is I say. Question A beside say, when can a petition be filed? So the first pointer is saying that a petition for divorce shall not be instituted within 2 years from the date of marriage. Obiaware Saturday came 2 months on, or say our enemy to me worry. For whatever reason, or say our enemy own to me worry. Now the question is, what the law is saying is that we will not allow you to bring your marriage to an end or file, or you be able to file an application or a petition, for divorce within the first 2 years of your marriage. Now, Obibeka say, "Hey, now, Emrawe, our 2 months, and koyi, and no maybe while we were dating, no, man, but some of these things have become very apparent, and they've become a threat to my life. The law gives exceptions to this rule, say you cannot bring a petition for divorce within 2 years. So the first one will be substantial hardship to the petitioner. The petitioner is the person who brings to the court the suit that he or she wants to be divorced. It could be the man or it could be the woman. Now the question is, what would we consider as substantial hardship? Obibese, whilst we were dating, everything was flowing very well. Na bibia da form kama. Na ye worry ye, anopa ye bomasum, area ye wo mesekan, anajo, anase nimre ye straight so shitugume ho. The court will not necessarily say that because we have made the rule say you cannot bring your marriage to an end within the first 2 years of the marriage, you should suffer all of these things, or the things that I just mentioned. You should suffer them because 2 years no soon. And as they do 6 months, now we now Sebio in Fasobeng and Abamrano. The law is saying that even though generally you cannot bring an action for divorce within 2 years of your marriage, you may only bring it when the petitioner, the person who is bringing the action, says that I am suffering some substantial hardship. And you must establish, sir, saying hardship beyond reasonable doubt. It is about court, you will say, baby, ya wo sekai awa market ya bobo o still to
Sabi you see baby atochima because it be biable. The law will not sit down or the court will not sit down for you to suffer this. Now, the second aspect of it is depravity. Now, if I can say, I know, I say respondent. Respondent, no, and the EBD assembly tiano. Now, say, about say, and let me just go, let's say, let me use this example. When a husband demands that the wife have sex with a third party in his presence or demands a threesome, something outrageous, something very silly that you do not expect that ordinarily you would ask your spouse to. If you are able to establish something like this, if you're able to establish one of these two, or when you are able to establish two of these at the same time, and your marriage is less than 2 years, the law or the court shall make an exception to the case and hear the merits of the case and possibly grant the prayer, i.e., to be legally separated from your spouse. Now, the next thing we will look at, why any bit to me a day divorce no aba. We already mentioned, say, it is one of the spouse, or they mutually, both can mutually bring it. Now, section 1 of MCA, now say law na a share a warrior who say 1. I just saw a Ghanani and Sana who to me the petition for divorce aba. And now say you are ordinarily domiciled in Ghana. And now say you have been living in Ghana for a continuous period of 3 years. Now, may explaining domicile no kakra because I don't know I said the technical kakra. Say kaso be a domicile to ha. And unche say or ye Ghanani extensor. But ebia obia free amanone and also free krobe so. Na wabet na Ghana ha. Na ote Ghana ha no or where Juma ewaha or sorry waha. As in, he has established himself, even though he is not a national of Ghana. He is not taking up nationality, or probably is in the process of taking nationality. If you fall within any of these categories, no, you may bring an action to court. Now, we will look at what constitutes or the grounds with which you can bring divorce. Can we move to the next slide, please? The next slide, please. Thank you. Now, in Ghana, the ground for petition for divorce is that you should be able to establish that the marriage has broken down beyond reconciliation. This is the only ground. This is the only ground with which anybody can say, I want to legally dissolve my marriage. Now, Obibe Bisa say, how do I know that my marriage has broken down beyond reconciliation? So the law has identified 6 points. The next slide, please. That if you are able to establish any of these points, and let me be very specific over here, say, if you are able to establish any of these grounds, or you are able to establish a multitude of these grounds, you should be able to bring an action for divorce. Niemrani kache ni se Ghana hanom se o de petition eba court say aware no yentwemu a and we say utumi chair say aware no has broken down beyond reconciliation. Now beyond marriage breaking down beyond reconciliation a broad into there are different spectrum, and I said there are various incidents you should be able to establish. No, you say, oh, our way, it has broken down beyond reconciliation. Now, the fact is, there are 6. Obibe bisa say, intino say, mikunu anase meye ebo ejamai enkwa. Can I bring an action on that ground? Yes, you may. You do not need a collection, and as you do not need accumulation of these incidents. You do not need these incidents to appear in a sequence. Once you are able to establish any of these points, and you are able to prove beyond doubt, and I say, to me, extra elements now, it makes up any of these ones now, you are able to bring the petition or an action for divorce. So let's look at the first one. The first one says that a person commits adultery. Now, see a share screen so the working definition here says adultery is the voluntary sexual intercourse of a married person with one of the opposite sex other than his or her spouse. So let's take note of some words in there. I say voluntary sexual intercourse of a married person with another person of the opposite sex than his or her spouse. Now, reading this definition, I know that a question has crossed somebody's mind. At this point, my preemptive will be question, a mature question, into the obebisa question. Na me adoma yeshia Sunday ya mema nipa korona adie. Now, after say uni obi wo ho, uni okunu wo ho, uni oye wo ho. Na in our local parlance, you can say oye afawachi, and I say ukunu afawachi. Now that is accepted as adultery. So the question that I was preempting that somebody is going to ask, say, enememu oba ni oba eda obema ni obema da. Intino se obema any oba, so obema any or another man ekwada, would that constitute adultery? Respectfully, did I preempt this question?
Oh, yeah.
Fantastic. So, what do you think?
Okay, so based on what you read, it means that there's no adultery here, unless say someone.
Fantastic point. Fantastic point. Say, yeshe interpretation now. Say, yeshe literal interpretation now. Nature say obema ekofa oba adultery. Nemo say obema kofa obema enye adultery. Until say we are able to establish it. There is a whole discussion on it, but I do not want us to veer off what we are discussing tonight. And I will just proceed. Now, we look at the definition now. There's another point that says that it has to be voluntary. Maybe that question I'm putting it to the floor. Where someone is raped, God forbid, would we say a adultery? Anyone? Hello? Anyone to
No.
attempt it?
No, I don't think so.
Okay. So let me give you another scenario. There is this position in the law that says that there's this position in the law that says that when two people have sexual intercourse, let's say Obema ni Oba no agrees say they are going to have sex. And the law says that during the sex, Oba can say, oh, ni biuma. And that's some person be biuma. And also Obema ni jai. Otherwise, it is rape. What would we think? Would it constitute voluntariness or not? Was my question clear?
Voluntary what?
So I'm saying that the question is...
It wasn't voluntary.
Shall I repeat the question again or shall I go
Yeah,
on?
come again, please.
Okay, so we're saying that the law posits that when two people are having sex, consensually, and during the act, the woman says that, I do not want to anymore. And if the man continues to do it, it constitutes rape. Using this scenario, would we consider, can we say that at that point when the person says that, I don't want to do this anymore, would we consider that as being a voluntary sexual intercourse?
Yes, I think so.
It's not voluntary. It's not
It's not voluntary, huh?
I think it's
No,
not
but
voluntary.
there's a portion that is, as in before they started the act and then to the process in the middle of the act. So
you see what we deal with as lawyers. So some question way, I'll leave it to the floor so that we play with it a little bit. When we have time, we'll come back to it and we'll discuss it. But the point I'm trying to say is that for anybody, for any of the spouse to establish that adultery has taken place, the person should be able to establish that it was a voluntary act by the other spouse to have sex with the other person. Now, the law says that just because you are able to establish that your spouse has had sexual intercourse voluntarily with another person, that alone does not suffice. Or say, you should be able to establish that besides the voluntary sexual intercourse with another person, it has become intolerable to live with a person. So I'll give two scenarios. The first one here said, Obini ni ye ewo ho. Obini ni kunu wo ho. Wafa ni kunu echi, wafa ni ye echi. The initial munu, or say, me domi kunu, me domi ye. Masom. That is one scenario. The other scenario, say, Obema no ekofa na eri echi. Oba no fa na eri echi. O say ohu ne kunu na na say ohu ne eri na sebio ne bufunu no. In other sense, we'll say that in trying to establish this intolerability, the man or the woman that says that I am disgusted by the sight of my wife. I am disgusted by the sight of my husband. And so if the party or the petitioner who is bringing the action is able to establish that, one, my husband or my wife has committed adultery, and two, I am disgusted by their sight. If the person is able to prove all of this, this can be one ground to establish that the marriage has broken down beyond reconciliation, and the court will grant it. Now, Obibeka say, what is the standard of having to prove it? Until again, you're being used to scenarios. Okoye, Obikacho say, Bunsa oye eshe hotel ha, and you be a and now if you Okoye no, Okoye would do when you gani say, oye, once you are able to see it now, it is beyond reasonable doubt. It's answer would when you now the other parts also say what applied to the court to bring an action for a petition for divorce. Now ground here adultery. Maybe so say we are then now who say uknu wafawechi. Oh, I see me see the catcher me say who say me kunu anyway shaho. And now say me kunu buy no me who say me share me the phone so no or nigga obi abonkomo and say internunti wafamechi. It could happen, say, the person is not, and also it's not even entertaining that person, but on to mean control the what text it, and also the what send it. Until that is not reasonable. When we talk about reasonable and also reasonability, it should be such that say obi and also otisa no beka say a deal way dear. The case offense and yes say near boy. So that is it for adultery. Now the second ground is unreasonable behavior. Now unreasonable behavior, Obibi say, what is an unreasonable behavior? Into you share offense saying the definition I put there now, and also the points I've put there now. It says the first one says that any conduct that gives rise to injury of life. Can we all relate to this? Say, only wukunu ewoho, and I say only oye woho. Na wakacho ye say, oh, sewa enemidi say. Na sewa eba wakacho say sewa disrespect you, and out of it no, or far there, edibuti, iti apai. And now say, Opa, with all humility, would ask her husband, say, yes, sir, mommy. And I say, me per se, then it did biara, ye bono. Say, ye jan the de bona, a belt and the de bono. A ye second ye do channel. Ye she asked the bono. Ye no, and mummy beer that brings physical or personal injury to the other spouse. The law says that if you are able to establish things like this, if you are able to say, and as it should say, there's been something that has brought injury, personal injury to you now, this unreasonable behavior will suffice. Now, the next slide says that behavior that gives rise to apprehension of danger. If you can say, or the idea child, But the idea was, say, who say Ukuba can now you must show. And now, who say, we actually say, can every child be baby and can now you must show. The apprehension of danger simply says that, and as this point is just saying that, just seeing somebody and it sparks danger in you. If you are able to establish some points we now, let's just say, the person's behavior has become unreasonable, and you cannot be expected to live with this. The next point will say that the conduct must be grave and weighty. It's if I say, and also now say, ebi a hon komo ye show ye ofie ye bibia na say bia ukun ebense obi a ukun abo we kakra and as body be say and gives you a pat on the back. I say ebia na unsem ye du se kwekwe jare a obo we chi na ja as the e but it was probably just a pat on the back. And now you're doing the action was such that a third person, and I say any ordinary person will objectively not say, oh, I did well, yeah, no proud. And I say I did one share that. It is a person or ground for unreasonable behavior, an accident. And I say people one share that. And oh yeah. Your ground for unreasonable behavior will not suffice. So, clear. Are we good?
Yeah. Yes. We go so clear.
Yeah.
Fantastic. So we move to the next point. That is desertion. Good. Now it says that what is desertion? So our working definition says that the first point is that the unjustifiable withdrawal of cohabitation without the consent of the spouse, of the other spouse, and with the intention of remaining separated permanently. I am getting feedback of myself. Na ukunu say and also you say watching you. Wama explanation be a one cache and show for a continuous period. Emran said, if you are able to establish these things now, it should suffice as being desertion, and as you have been deserted. Now, you can't desertion now. That point we are making, I was said, you should be able to establish that you have been deserted, and I say, sa rule now, I was say, and I say, also, no. For the past 2 years, continuously proceedings are actually on there. Then now we start the discussion. And then prelims. But now we have to, under desertion, the law says that we have to establish 4 points. The first one being de facto separation, animus surrender, lack of consent from the other spouse, and want of reasonable excuse. De facto separation, HSA, will withdraw the always said, or Yemani be a. So if we go to the next one, it will say that actual withdrawal of all marital obligations, Oniakohoma, on Medefi, Sebio, on Fanu count, on so. The next one is complete cessation of cohabitation. I just said, you know, if we system, I just said, he wants, from his behavior, it can be inferred, say he wants nothing to do with you. He has stopped performing all of these things completely. Now, that is the first one. So we go to animus discerrendi. So the first point is that there's a complete end to cohabitation. So for the purpose of this discussion, we refer ourselves back to the earlier point that this is not cohabitation, say, but cohabitation, I say, we are living together under one roof. Say, yet a die back, yet a fear back, say, there's a complete end to that. The next point we say, a temporal end will not suffice. In the end, they say, me wo yemi ni Ghana. I mean, you come now, but say, a jumanti, I will say, me too quite. Na se wo Ghana, na se bi a me wo London, and na se me wo Canada, and now China. It cannot be said, say, I have completely deserted you. It's unsaid, baby, I'm a any baby, I want to. You to me, can say, I dare saying, yeah, bisa. Now, Obibe can say, now for how long? The next point, we'll look at that. So I'll not go much into it. So a temporal end will not suffice. Another example, say, Ebia, yawoho, na yenyan toka, akasakasa aba, intino, obia buefu, obia should be any. Ebia for 6 months, you will hear some stories, say, Ebia, for 6 months. And that's for a couple of, for some time. Bearman, if you're near home, if you're my fee, and also Befi, but or no room. That will not suffice as animals discerrendi. So the next point will be lack of consent. I'm sorry, before I go to lack of consent, let's look at the third pointer. It says the spouse must have the capacity to form that intention. Actually, say, Bemana o fie, Obana o fie, one million now, when they actually decide on their own solution to discontinue with this cohabitation, they discontinue it completely. It is one that it must be from them. So you see, the exception is that an insane person cannot have such capacity. In a sense, say, Sebio Ubia or what Adjumuyare, or yet mentally fit to say, I am doing something like this. It may be our lucid moments, kakra, or your bed, now for crisis, kakra, ba, and also your bed. It will be some, you cannot say, Bibisa, Esi, that there's been complete end or complete cessation of cohabitation. Again, the last point is saying that when the parties agree to a de facto separation, when the parties are in different jurisdictions, as I mentioned earlier, desertion would fail. So in a nutshell, for you to establish that, so for a person to, and also a party to establish animus discerrendi, it should be established, it should be such that per the person's own volition, they have completely ended cohabitation. With 12 and no Sam, na yekikako. So we'll go to the next point, that is lack of consent. Intino. Me na me say, I need some time off. and I say, I need a little space. And I say, Eduma Abba, I will say, if I'm feeling crying, now me contact credit, and now come and say, and both parties agree, say, yes, you can go. That you have consent from your other party, you have consent from your other spouse. Or we say you have permission. You have permission from your spouse to go. And so once you see the next point saying that consent vitiates dissension. Once you have consent from your other side, you cannot be considered or you cannot be said, say you have deserted your partner. The reverse is that you have left the house. You have withdrawn from performance of all marital obligation without consent of your wife. What you are supposed to do for your wife. And I say the benefits that your wife is supposed to get from you. Now watching with one manual explanation. Once the person is able to establish some points that the consent in you are, then also the whole point of desertion is almost being satisfied. So the last one is want of a reasonable cause. I didn't know Fifi. I don't know. I just felt like with Fifi. That is not a reasonable cause. And I say, I need space. Yeah. The baby is crying without reasonable cause. But the baby says, I'm sorry, the spouse says that, and then I don't feel like, and I say for this time, I don't feel like being at home. Intimate with you. And I say, and I say, it is not a reasonable cause for you to withdraw. Nemo, if the person says that, or withdraw because Bibi Woha Oye are affected now, there is reasonable cause. And so the person's withdrawal now becomes justified. And now we'll be looking at behavior, and as a cause will now become an unreasonable behavior. It will not be desertion, but it will become unreasonable behavior on its own. But the reason why I'm watching away from, and I say that what you are supposed to do, it becomes a flimsy excuse. And so we move on. One other thing that I'm going to talk about that I think is not in my slide, but I will still discuss, that the parties have failed to live together as husband and wife for a continuous period of 2 years. Now, earlier on, whilst I was talking about desertion, I mentioned, I used a scenario where I said, say, a party or the parties have agreed, say, ABR, we are going to look, the man is going to look for greener pastures. So for a continuous period of 2 years, they have not lived under the same roof as husband and wife. However, Bemano and also Obano will consent to be outside the jurisdiction. They are in constant communication. So they are not considered, say, even though it's for 2 years, so they have not been in the same space, they will not be considered, say, they are not married. A baby now that is what it is. However, the opposite is Bemani or Bani na ewo krum ha. Now, for the purpose of this example, we Obani ti dansuman. Bemani ti odoko. Obia ti ni baby. Obia mfo obia ho. Obia the Bemanu ni akoma Obani ni aduane mani kunu. And so other people know say, oh, worry. The law says that when something like this happens, or when we have a situation like this, one of them may bring an action that says that we are not living together as husband and wife. And that should suffice as a ground that the marriage has broken down beyond reconciliation. Because the argument is, say, if there are no conflicts between us, why is it that what's your doko and I'm instrumented down someone? And I haven't given reason, I haven't given consent side to our doko, I'm instrumented down someone. So for them to have continuously done that for some period of 2 years, they may bring an action for divorce. Now, for Bibeka say, it's 2 years, in fact, say it started in January. Now, at some point in time, within that 2 years, very many befi, if we are doko about downsuman, it's not the same roof. No much you come. After 2 months, was I reverted, come back to Odoko, would that suffice? The law says no. So that is why the emphasis is on that there has to be a continuous period of 2 years that the two parties have not lived. Again, if within that period there has to be some kind of proof. And she said, Bia, Bibi saying Ena Obano, and I said, Beman up now. You have to prove that there's been some kind of matrimonial offense for that action to suffice. So then whatever points that we just discussed briefly over here, the same applies to failure to live as husband and wife for a continuous period of 5 years. And understand, see a bar, the Becca say, okay, continuous period of 5 years preceding the petition, the parties have not lived together as husband and wife. There is the court would not require anybody to prove say something has been done. There was a reason why a man or there's not been any matrimonial offense for a continuous period of 5 years. And also, some matrimonial offense, things like, fights or things of unreasonable behavior, all these things, they will not be considered. Once you have lived, you've been able to live for a continuous period of 5 years. What you are telling us invariably is that you people do not have any business together. And the law will not even allow you guys to come and waste its time. If you don't want to live together, level. So that's it for failure to live for a continuous period of 5 years. Now we go to our next page. If we can go to the next slide, that has discussion of Kute versus Kute. Now, case we very interesting. Now, parties not all outside Ghana. Worry, the facts are there. Now, Obano, Omoba Ghana, ni no be din kaka emao. Intino, Obano, enya eduma
etua ni ye wo Asante Agogo and obema no say engineer wo Mase. Now we shall say between the period of 1967 and 1974 parties no almost now together as husband and wife twice. And then who almost say as husband and wife, they lived in separate rooms. It is a obani free agogo, about Marcia. Just say if you know a fear back, Namun Obana at the dime back, and Obama that dime back. It is a calculating the period between 1967 and 1974. That's a continuous period of 7 years. Into Obama the case no court say aware no when you aware you. Now Obama so by or say, oh, Odonuku, it's eventually says the assembly between them. Now the argument will be said, we will look at it further. So I will just leave it here. But the argument will say, so Obama will say, Uja warrior. Now say, Obama will say, Odonuku, should the court allow them to proceed? We'll come to that in our next few slides. But the court held for the petitioner, Berman, and say, Berman say, Obano say na oye. Na ushe facts now say, Obano do ifilimu. Na say Obano do ifilimu. Na say time no po odono wo hono. They were not living together. And within a period of 7 years, they only lived together as husband and wife twice. It makes no sense to keep them together as husband and wife because the courts will not grant specific order in times of divorce petitions. And to say be a contractor, I shall say, yeah, we or say, or don't know article. So he doesn't want to be there. And that's the thing. And so if you look at the calculation now, for a period of 7 years now, we have exceeded the required number of 5 years. And so the divorce was granted. Now, the last point that, or the last ground that a person must establish that the marriage has broken down beyond reconciliation, as I said, we've been unable to reconcile our difference. Let's just say, if you look at the previous case now we discussed, now Kote versus Kote, a buyer saw Bema so Oja Warrior, or Banso Beniku, and the Bushiat say, and you see the assembly. And you say, but this point is saying that they cannot come to an agreement. And I say in law, we will say their minds are not at them. Or nearby. So can we have we see me say? Who can say we see me say? Every time I say there is conflict. You know your own say. In the case there one Mensa versus Mensa. The fact we say Obama na our health issue kakra. Into na onto me and to me, he was unable to impregnate a woman. Into the wife, actually said, and the young hospital near show, Yema withdrew. Na ensa yare, send a beya, give it to me. Obanika, Obemanisi say, Obemanika say, Obanisi say. And so, from the facts, it had become apparent, say, they could not agree on one thing. And like I said previously, the law will not grant specific performance in instances like this. And Mama and shall we say, once a marcus will go wide, the law would allow you to proceed. So if you look at the points that we've looked at, that
in Ghana, for anybody to establish that a marriage has broken down beyond reconciliation, you have to first and foremost state all of this. You have to state all of these points. You have to state all of these facts. Now, in stating all of these facts, you need to be able to identify the individual elements. You need to be able to identify the various elements within the points that we have touched on. So failure to do this, failure to satisfy these individual points within the general 6 incidents, now your action for divorce will not suffice, it will not hold. Now, on our last slide, that says promoting reconciliation. The law says that at section 8 of Act 362, I will not read the whole text, but essentially says that if at any stage during a divorce or not during the proceedings of divorce, it is established that the parties want their situation or their actions to be amenable to reconciliation. And Mano, Ebema Hokai said, in fact, if you look at your court acts now, and as it's the outlook of the law these days now, the law is looking at ensuring that there's reconciliation even in criminal matters. We are looking at bringing parties to their original state. It is not the wish of the court to say that we have brought or we are bringing things that have been mutually agreed to an end. And so, looking at all of this, the question now is, and that's the discussion, which has not been encapsulated in these slides, ASA. How would it be? And as a Christian, YAF, over time, would say you've been taken through the rigors of it. It shall say, you go through a process like this. Let me just say this. The rate of divorce in Ghana is skyrocketing. In fact, I've had a conversation with somebody recently, and it's also statistically, I say almost 5 out of every 10 weddings that are apparently a minister and that take place are due for marriage at one tenure. One tenure within 5 years. Their life expectation, the life expectation of their marriage, 5 years. I told the beer, 5 years, the discussion that we had earlier said 2 years, it's with them. I have seen it many times for that matter. So I'm not surprised. I have seen instances where people get married. In fact, the person got married last September. I was there. January 2, and that's the January 2nd. I was there. I was at Dansoman. I was in my car, driving right in front of Ensunyame, and was sending me text or sending me a snapshot of email. Sending to say, "Opeso Jai Aware." September no warrior. I know people who, this conversation was had just 24 hours ago. I said they've been married for 8 years. Now, so aware because now a year I said not all ye girl in favor. The reason why I am pointing these things or these facts to us is to say, aware no enough from Sebu, we I don't know what's so easy. Even a na, yeda. I told you, Obeka said to me na. But sleep is supposed to be easy. You're supposed to lie on your bed comfortably. No other. Let's not look at marriage as checking a box in life. Now, I am not speaking as an astute person who has knowledge of the law. I am speaking as a peer, as a Christian, as someone who's at the forefront and seeing what is happening with this whole thing about divorce, because divorce is wrecking people. It is wrecking homes. And if you think, say, in Romaya, you're discussing a way, and it's so easy, say, be our court. No, I can't for one day. Okay, bro, for no Monday, Friday. Yes, I say you have your license, you are single. That is not true. It is something that spans for years. And once you've been able to even prove all of this, there is another massive subject that is, what you call it, spousal property. That is another war. In Sebusia 4, and rather they are kind of that's my kind of material. They sure say after this there will be questions people will have to ask. But let's understand that nothing is easy. And we should always understand and appreciate what we're getting into before we get into it. On this note, ladies and gentlemen, I want to thank you all for listening to me, making time to listen to me. And I will end my presentation here and welcome questions. Thank you very much.
Thank you so much. Yeah, that's it. Your brother. Cool. But your better questions, so do your questions, questions are welcome into the batch. So do a question wait more mute and over page and sana yaman platform. Yeah, check questions. So number say I also like to acknowledge the presence of second minister, Papa, Reverend Odati Akwa. Papa, yeah, that's it. Thanks for joining. And also your mame Cynthia and also adjoining Zoom. So as soon as the YPG president, sister Jacqueline Ampofo, and also adjoining Zoom. But yeah, questions. What's your screen is also and we have our Momo line. The Abumo number also at so whilst I questions no na Sanji offer so account kakra will be opposite with the supportive fellowship no na ode aboa. Your former president also and also online, your brother Clifford, Mr. Clifford Odame. That's why that's be. Thanks for joining us also. But yeah. Brack we my man started. During your presentation, okay, says only oba have sex now oba ne ka say ebia onye bioma won kwan say obeja. Don't you think say this you know na a lot of rape accusations abano? See bi oba no obeye wi na later no asan kwa ka say o share no na one ne die.
So I know, sir, yes, sir, the rape cases are rampant. And sir, it's a fact in the case. A case something that happened in England. And because Ghana, our legal system, we draw it from one of our source of law is the common law of England. So we are able to use some of these laws and apply it to Ghana. We always need to understand, say, consent or lack of consent
is a vitiating factor. Once consent is given, there is no liability. However, when consent is not given, any other thing is a liability. And I understand, say, during intercourse, you probably will be having fun. You're having a good time. But what the decision in this case is saying is that you don't have to lose your head, because when you lose your head and the person says that I want to discontinue with this act, you immediately have to stop. At that point in time, no, people can say, why is selfish? But it is better to heed the person's request at being selfish rather than pursuing your own gain, because it will be to your detriment. Rex, what's my chair? Hello, Rex. You see there? I suppose Rex is off. Hello?
Oh, Rex is I think so. He's gone off.
Okay, so I hope when he comes back on, I'll probably reiterate my response.
Then she go about and say, why we pin?
But I'll say,
but sorry, but what's my cafe? Not network, no.
Yeah. But I'm sure the mechanic not say.
Then I'm a part. MT.
Right.
Okay. But then I don't know. I was having some network challenges, but then I'm a patch and say, maybe I might your opinion so much, but they will go on no our report will say why we pin on one testimony no. Don't you think say we no so can?
Okay, so like I said, the scenario I gave me was the consent was taken back during the action. Now, say one my consent say we should have sexual intercourse. Now, now can say you did not give consent. You would have to prove. And you see, Rebecca say, how would I be able to prove? I will not give that information out because you see, the law is a sword and a shield. But say Uba, say Ibia Oba, only Obama have sex, and then you agree to it, and after everything has ended, you now come and blackmail the person. There are ways we will use to find out.
Like
But yes, there are ways we can use to find out. We will find out. It's just that, like I said, I can give the information out, but it could be a shield in the hands of the right person, or it could be a sword in the hands of the wrong person. So don't think, say, just because something like this is happening, or no, there are ways we'll find out. Yeah. So thank you. Any other questions, respectfully? Okay, Nanesi.
Thank you. I wanted to find out from like where you sit as a law person.
Right.
Why do you think the divorce rate is skyrocketing? Thank you.
Okay. I'm happy you're asking this question. Now, I remember when I went to law school the first time, my ADR lecturer, he made a comment saying, "Onuna warrior there, protected, but who do I worry about? Na peso guna, onobeya ma umajinisika." I will make another scenario and then I will join this. The reasons why divorce is on the high should go back to the parties. We should ask ourselves why we are getting married. I know people who have gotten married because of wealth, fame. I know people who have gotten married because Sebi, Obano Tuson. I know people who have gotten married because the guy, all she wanted is a tall, dark gentleman. In fact, yesterday, I was having a conversation with a friend, and one of the things that came up was, getting married to the person so that you can have benefits to some of the things the family has. And the point I drew out, they said, it's first and foremost, you are not being fair to yourself or the other person. It's just that the reason for which we are getting married has changed. We are getting married to check boxes. We are getting married to meet the social criteria. Another ground for which we are getting married, they said, divorces are on the high, and they said, young parties, we go into marriage knowing, say, there is a door of till death do us part, or there's a door of divorce. Another pointer to say, very predominant, say, at our ages, some of us are now making so much money, getting the privilege to have higher education, exposure, that we are independent in our own rights, that we cannot coexist with others. This is emphasis being mine, and just mentioning a few that I know of that I've been privy to. But I feel sad. There is this disjoint between family, and parties, themselves, and I'll say the church, because they say, like I said, the counseling is an expectation. The emphasis is mine, and I believe people will have other reasons, but these are some of the reasons why I think, say, the divorce rates are on the high. Now, Nancy, does that answer your question?
Yes, it does. But what I also have to say is that, okay, this is a church platform, okay. Right. The society in our church, the culture in our church, I can really say that is playing a part in this thing. Okay. Let me use myself. Mm-hmm. I got married 30s. And before I got married, I got to a time where I decided to stop attending a wedding in our church. Because anytime I go to a wedding, somebody will see me and say, yeah, whether I am ready physically, spiritually, mentally, financially, or whatever it is. Nobody had chance to stop or pause and then think about that aspect.
Yeah.
So I think that most divorces are from our Christian homes. You understand? Absolutely. It is the people of those of us who have had in our churches that are divorcing. So I think that the church should do its side. The church needs to do something about it, because if they break up The only thing is that the other person, one person will leave the church and then one will stay or whatever. They both live, and that kills it. Okay. The counseling thing we are doing, it feels like a textbook that we have to read.
Right.
Right? It's a formality. Go through. Oh, one who counts me, I am my own life. How many of these married people are breaking up? Just a few. I'm sure it is who have had the church weddings that are doing it. And when you go to the courts, they go back and forth. Some take years.
Yeah.
And it even affects the children if they are in there. It affects you emotionally and all that. So please, that is my side. I think that the church needs to do something about this our issue. Thank you.
I agree with you, Nanisi, and I'm happy Papa is on the line, so I'm sure he will comment on it. Thank you very much. Augustine.
My question is, you were saying this whole process takes so much time, right? Before you are even licensed to celebrate. Is the process prolonged? So what you are waiting, there's a possibility of them coming back, or is long?
Okay, so I appreciate your question, but you see, the courts, first and foremost, there's a certain expectation that the cases should be dealt with in a certain time. However, during a typical case, there's a structure. So you serve a suit or you serve a writ, there is a response, there's a statement of claim, there's a statement of defense, there's a reply if need be, there's something we call case management conference, the case is set down for trial. These are all, they are standardized time for all of these things. However, during litigation, things come up. People ask for adjournments. You understand? Sometimes it becomes a necessity for the court to order that something should be done. You understand? And all of these things, it gets to a point too that sometime in the year, the court also goes on what we call legal vacation. And so all of these things, prolongs the case. So the last divorce that I was privy to, it took 3 to 4 years. Now, the matter was settled, or the case, the trial, they did everything within, I think, 3 months. That was about 3 years ago. Now, the spousal property, how we're going to share it became an issue. That alone took 3 years. And in the end, what both parties were asking for, they did not get it. The court now had to relook at their prayers and give what it deemed equitable to the parties. So it is not like there's a structure or there's a determination of how long it can take. It just depends on how the trial goes down. If everything is straightforward, people prove what they need to prove. There is no difficulty in the prayer, because in the petition, you would have to make prayer what you want. If the custody of children, what you want, houses, cars, if everything goes smoothly, the expected time should be shorter. I don't know if that answers your question, Augustine.
Yeah, please, that does. I thought maybe the process is prolonged. By the time we called back, maybe the couples would have settled issues amicably. But now that I've explained it to me, I guess I'm okay now.
Oh yeah, I mean, once the couples settle the matter amicably, the issue is brought to an end. Only that in law, there's something called res judicata. They are not, just because they have been able to settle their difference, if at some point in time
something comes up, something different. So let's say during this divorce petition, the person committed adultery. Now they amicably settled their differences. They were living together. Now, any of the 6 things that we discussed has happened, and the party brings another divorce petition. They cannot make reference to the previous one, but the current one shall be grounds enough to end the marriage. That's if it's been able to prove, or the party is able to prove it. So yeah. I'm guessing there are no more questions.
So, please, the adultery part. No. Hello.
Yes,
the adultery part. The
right.
And now really okay, one is for a man.
Right.
Now say pana. Do you still call it adultery?
Okay. So if you look at a way now, we looked at a working definition. For you to prove, say, an adultery, I will say, you can say voluntarily, or new black and that's alone adultery. Now, when we bring in, say, wawari or bafufro now, it becomes adultery and something else. So, for instance, if wawari you're signing a marriage under ordinance, not say he voluntarily has sexual intercourse with another woman other than you. Not say he has committed an offense called bigamy. So that is another discussion on its own. Once you are over your petition now, Rebecca say we need to satisfy, say, 1 of our chief, 2, and 3, he did that saying on his own volition, and he knew what he was doing. Once you are able to establish that 3-way, adultery will suffice as a ground for divorce. I think Nanisi is gonna, Nanisi, is that clear? Fantastic. So Dami, Chief, I salute.
I take up Your Highness. Yeah, I want to ask,
right,
from where you sit,
right,
as a lawyer and as a Christian,
right,
and see the rate at which the divorce are happening, then the problem that ordinance is creating,
right?
Will you still recommend ordinance, and will you encourage the church to stick to the position of ordinance even as of now?
I've had a very long argument about this. First off, like I said, there are 3 kinds of marriages. One is peculiar to a certain religion, as in the Islamic religion. As a Muhammadan, so that is outside the FNC. So we are left with the customary marriage and ordinance. It is a matter of choice. It is a matter of choice which kind of marriage a party wants to have. I cannot use my discretion. What I can do is to advise the pros and cons of each, and then you make your decision. That's the first part. Now, the second part is, if you look at the ordinance marriage, there are three types. The Obeko district, there's a district, I don't know if I should say the municipal or the district within which you live in. You can actually, if that's a registrar, marriage by registrar's ordinance, you can go there and they will sign the official documents. You just have to meet the requirements and you'll be married and will still be considered an ordinance marriage. 2, you can come to you can come to the church where the church has been given the power that the church is a place where you can, the minister in charge has been ordained and has the legal requirements to ordain a marriage. You can come there and they will do it for you. Or 3, you can go to the special registered ordinance. That is when you go to company's registry and you look, there's an official who also governs this marriage. He will sign, you will meet, if you are for AMA, if you are for company registry, and the ordinance. And so you may take the church out, the aspect of the church where the reverend minister will come and look at proceedings, but you can still have an ordinance marriage when you go to the other 2 avenues. In effect, the choice of marriage, and as to which kind of marriage a person wants to do, is always a choice that the parties want. What people within the legal sphere or window or frame can do is that we can advise you on the pros and cons, the ups and downs on both sides. Then you can choose. Senior, respectfully, I hope that answers your question.
Yes, it does. So the advice should then come more in the check, because I think that one is lacking. We are having a lack of it, and it's like ordinance all the way. So I think maybe the church can also take a look at that. Thank you.
Now, based on what you just said, let me just use that to advise everybody on the platform. Because this is a Christian platform, the aim is that, and I say the goal is that if we are also in Ninara, na say uba asori. They say about asori, they say yebeji nyankopon shia celebea or software. The GD said the Lord Himself has ordained and touched. We will speak grace, favor. We will speak words of blessing to our marriage. That is why we do that. But in the earlier conversation with Nanesi, we realized that even the counseling, is just a requirement. However, as to whether the counseling has become effective or not is the rampant and as the increase in divorce numbers. And I don't know what the church can do. Say yebeno empire, and I say we will make our counseling process very tight, very stringent. And you say it's just a requirement. That would help. And also the extended family, we have to empower them Some empire said they are just bystanders. Say a wife for yen isika, and you see any other into a prayer idea. We are going to do it. No. So basically, that's about it.
But
I assume the question.
We'll take the last two questions. Say be all there. Okay, so we say be no dear. I also like to acknowledge the presence of your immediate past senior presbyter Auntie Abrebese or joining our YouTube. My Dasi Bibre say Bajimbre about the kind. But on the final round of questions, say it be was so it be new sir then but
yeah, just a quick one. Now, we're talking about the proof. Say you have to prove beyond reasonable doubts. But what I know is that the divorce is a civil case. It's not a criminal case. So where the issue of proving beyond reasonable doubt, now it's a magic. So we wait to teach you.
hello, Bragg, we go back to what's the anchor? But say the network, no, Mr. Adami, please. I'll take your question.
Hello. Yeah.
But the final round of question. Now, Mr. Adami, bisa question.
Yeah. I had this question.
Oh, okay.
So what I was saying is so share Ghana memoir, evidence decree from sections 10 to 15 talks about burden of proof and the standard and what is expected to prove a matter. Now, we share section 11.1 now. It says that for criminal cases, the burden of proof beyond reasonable doubt, and for civil matters, the reasonable preponderance of facts. But if you look at section 13 of the evidence decree, it allows us to invite or bring in the beyond reasonable doubt, even in civil matters, section 13 and section 14. Because when we say something is beyond reasonable doubt, it is the highest standard of proof. So proof you can say the beyond reasonable doubt. Let's just say you cannot have anything contrary to the existing facts. So let me use this example. There's a case. The citation here, Ajete versus Ajete. In Ajete versus Ajete, we they made sure idea kakra. Obani bema yetefie ena yesi yetu. Ya bobo ye no man ena at the due time say ye beko. Obani say, oh, you kind na me back me do what you metraka from the medikwaba. 6 months down the line, Obani mai sending no beba, I don't know. Afi bema no Obani wafa e the Obani befi and almost see asem and Obani sign by. A few months later, Obani sign free and Ofi no one you say or say Obama for car front. And evidence who said there's record of the woman and another man at another hotel. Even though they have not been seen to be having sexual intercourse, cumulatively, beyond reasonable doubt, when you present these facts, everybody will know, say, something must be going on, something is going on. Even though, say, reasonable doubt is criminal matters, no, the beyond reasonable doubt, no, the highest level. So to prove adultery, it has to be beyond reasonable doubt. And yes, Anna, I hear say. Senior, is it clearer?
Oh, yeah, yes, sir. Yes, sir. I'm okay.
Thank you.
Thank you.
Okay.
If I try move fan count law for no move fan count say obi enu obetimi abe waste your time. Na bet na say ahwe no na waware. No wako jina baby decide say me jai keke. That is why you have to prove beyond reasonable doubt move fan count wa pacho. Thank you all.
Okay. Yeah, that's it. Nanesi. On behalf of the executives, I would like to thank our speaker, Mr. Kweku Opoku AG. But you said the medical or a legal consultant or Ghana Health Service. And also a member of Ramsey congregation. TBA so be was saying the CB one man. We wait to contact any of the executives, YAF executives, we be any contact or no. And also thank you for helping us become more aware of the problems associated with divorce and acquire retina faso as solving. Mesanso ada obi biara say ojembre ebe joining I may have a fruitful discussion. So with the message I say you bet you to your home. Na ya chair adom sem na di dwumadi mu aba ewiye. Come chop mama yon miti oni encha adom sem na time ko ye pa. But you na be chair adom sem ne say yen erade
Kopondo.
Amen. Have a wonderful evening. Pamucho Namia Duma Otuna program no a health talk, a narcissistic personality disorder. Yeah, to our OCD ne so ntino. Yembo moderne ina on time. Medase.
Nanesi bo afore.